Assalamualaikum warahmatullahi wabarakatuh. Welcome back to Family Law course. We are now in the topic of domicile. Okay, for the topic learning outcomes, at the end of this topic, students are able to explain domicile and the importance of the domicile, elaborate types of domicile, and apply the domicile principles in solving legal disputes in family law. Choice and domicile of depend. Also, test to determine domicile, dual domicile test and intended matrimony. We also will exception to the test and the law applicable in Malaysia relating to domicile. Okay, now definition of domicile. Domicile is a place of residence or ordinary habitation. Okay, it also means a place where one has his permanent residence, to which if absent, he has the intention of returning. In the case of hopes, domicile is referring to a place where a person has voluntarily fixed the habitation of himself and his family, not for a mere special and temporary purpose, but with a present intention of making it his permanent home, unless and until something which is unexpected or the happening of which is uncertain shall occur to induce him to adopt some other permanent home. Okay, now we go to the differences of domicile, citizenship, and citizenship means political status, right? To vote, and for residents to reside or to have one's usual dwelling place. Okay, in domicile, a person can only have one domicile at any one time, but for residents, one can have more than one places of residence at one time. In domicile, for domicile, to prove domicile, no documentary evidence is needed. But for citizenship, it can be proven by documentary evidence, for example, to show your identification card or passport. Okay, we move on to the application of Law Reform Marriage and Divorce Act, or also known as LRA, as regards to domicile. Okay, Section 3 of the LRA states that subsection 1, except as it otherwise expressly provided, this Act shall apply to all persons in Malaysia and to all persons domiciled in Malaysia but are resident outside Malaysia. Subsection 2, for the purposes of this Act, a person who is a citizen of Malaysia shall be deemed until the contrary is proved to be domiciled in Malaysia. Subsection 3, this Act shall not apply to a Muslim or to any person who is married under Islamic law, and no marriage of one of the parties which professes the religion of Islam shall be solemnized or registered under this Act. But nothing herein shall be construed to prevent a court before which a petition for divorce has been made under Section 51 from granting a decree of divorce on the petition of one party to a marriage where the other party has converted to Islam. And such decree shall, notwithstanding any other written law to the contrary, be valid against the party to the marriage who has so converted to Islam. Subsection 4. LRA shall not apply to any native of Sabah and Sarawak or any Aborigine of Peninsular Malaysia whose marriage and divorce is governed by native customary law or Aboriginal custom, unless they elects to marry under LRA. B, the second one, they contracted their marriage ordinance, or Malaysia have choice whether to subject it A or not. Okay, the native from Sabah has the same meaning, 161 and domicile and residence. The domicile and residence of a certificate of domicile and residence, the appropriate provisions under LRA are section applicable under LRA, section 3 subsection 1 of the LRA, except as it otherwise expressly provided, this act shall apply to all persons in Malaysia and to all persons domiciled in Malaysia but are resident outside Malaysia. Next provision is section 3 subsection 2. For the purposes of this act, a person who is a citizen of Malaysia shall be deemed until the contrary is proved to be domiciled in Malaysia. Next is section 26 subsection 1. The issue of domicile is important for marriages solemnized overseas but in accordance with LRA. The next one is section 104. The issue of domicile is important for marriages solemnized overseas according to the law of the foreign country. Next section is section 105. The issue of domicile is important for the recognition of foreign marriages contracted in any foreign embassy, high commission or consulate in Malaysia. Now we go to section 48 subsection 1C. Okay, this section states that nothing in this act shall authorize the court to make any decree of divorce except where the domicile of the parties to the marriage at the time when the petition is presented is in Malaysia. We are referring to the case of Long Yan Fei and Paul's Baya. The petitioner wife and the respondent contracted the marriage at the Bintulu Marriage Registry in Sarawak. They had cohabited in Kuala Lumpur. After some differences, the respondent moved to Kuching while the petitioner continued residing in Kuala Lumpur. The petitioner petitioned for a divorce. The issue now is whether the High Court in Malaya possessed jurisdiction to entertain the petition arose, and the petitioner contended that since the respondent was domiciled in Sarawak, therefore the High Court of Sabah and Sarawak had the correct local and territorial jurisdiction on the case. The court held that section 48 subsection 1 of the LRA elucidates that when parties seek for a divorce, both parties must be domiciled in Malaysia. Therefore, since the petitioner and the respondent were domiciled in Malaysia when the presentation of the petition was made, the High Court of Malaya has jurisdiction to hear the case. According to section 49 of the LRA, subsection 1, notwithstanding anything to the contrary, in paragraph 48, subsection 1C, the court shall have jurisdiction to entertain proceedings by a wife under this part, although the husband is not domiciled or resident in Malaysia, if A. The wife has been deserted by the husband, or the husband has been deported from Malaysia under any law for the time being in force relating to the deportation of persons, and the husband was before the desertion or deportation domiciled in Malaysia. Or B. The wife is resident in Malaysia and has been ordinarily resident in Malaysia for a period of 2 years immediately preceding the commencement of the proceedings. Okay, now we go to the importance of domicile. Domicile, why should we determine domicile? The domicile is important to be determined for the purpose of the validity of the marriage, the jurisdiction of the divorce case.